Let's talk about statutes of limitation. I think most of us have a general idea of what statutes of limitation are based on TV shows and movies and everything else. But like so many concepts that we hear about in the media, all that we know is a label and we don't really understand what they mean. There are three aspects to every statute of limitations issue. The first issue is the limitations period. Here in Minnesota, for example, the general statute of limitations for most claims is 6 years. But we have other lawsuits that require you to bring a claim within 4 years or 2 years or maybe even 1 year. So the limitations period varies from the type of claim you're bringing. In a lot of states, there may be different statute of limitations for a medical malpractice case versus a regular negligence case. There may be a different statute of limitations for damages to property versus damages to someone's person. So you have to look at the type of claim you're bringing, and also you have to look at the relevant law. If you're bringing a state claim, then you have to look at the state whose law would apply to the legal issue. And if you're bringing a federal claim, you would have to look to federal law to see if there is an applicable statute of limitations period. That question itself, how long do you have, can be very difficult, especially when you have claims that may arise in more than one jurisdiction. That's the first issue. What's the limitations period? For purposes of this discussion, I'm going to use 4 years. The second issue you need to understand is accrual. So once you figure out what the statute of limitations is, and in this case I said we're going to use the general time period of 4 years, then you have to decide when does that 4-year period begin to run. It's not always obvious. The fundamental principle of any accrual rule is that a claim cannot accrue, the statute of limitations cannot begin to run, until all elements of the claim exist. Let's take a simple negligence claim. A negligence claim requires proof of 4 elements: duty, breach of duty, causation, and injury. So the driver who goes through the red light owes a duty. They owe a duty to stop at a red light. That's what a reasonable person does. The driver breached that duty by not stopping at the red light. Causation, of course, occurred when the car struck the vehicle, and injury was the injury to the vehicle itself, the property damage, all the body work that would have to be done. Maybe the car is totaled. The insurance claim would take care of all that property damage, and there may also be bodily injuries, broken legs, scars, whiplash, soft tissue injuries, whatever. So you would need all 4 of those elements. Now you only need 1 injury. You don't need whiplash and a broken leg, and you just need 1 injury. The damage to your vehicle would be enough of an injury. Even if it was just a tiny little scratch, that injury would be enough to give you standing to bring a negligence claim. In the case of a car accident, accrual is a very easy question, because as soon as the car flies through the intersection and strikes the other vehicle, all 4 of those elements spring to life immediately. And so the claim accrues immediately, and the statute of limitations begins to run immediately. The driver of the car that was struck would have 4 years, if the statute of limitations is 4 years, to find a lawyer, to research the claims, to put together a complaint, and to file a lawsuit. Accrual isn't always an easy question, however, when you're dealing with injuries that are concealed. Concealed injuries often come up in malpractice cases or in cases of financial fraud. So you are a patient and you go in for surgery. Get done with the surgery, you wake up in the recovery room, you look at your belly, there's a scar there, everything looks fine. For 15 years, you live, you have absolutely no problems. It's the only surgery you've ever had in your entire life. And then, lo and behold, 15 years after that surgery, you get this flaming infection, and nobody can figure out what's causing it. They x-ray you, they can't see anything. And then, just out of sheer desperation, you go in because they're going to do a second surgery just to try to figure out what's causing this infection. And they go in, they do the second surgery, and they find a sponge inside of you. The only logical conclusion is that the sponge must have been left inside of you after the first surgery 15 years ago. The law wouldn't expect you to be aware of your injury when there are no consequences to that injury. You're injured when the sponge is left inside of you, but your lack of knowledge relating to that injury cannot possibly trigger the statute of limitations. When you've got a discovery of injury situation like that, the statute of limitations is often postponed until the injury manifests itself. In this case, until the infection arises. Then once the infection arises, you've got 4 years to figure out whether what's the source of that injury and whether that injury gives rise to any legal recourse. That's a discovery of injury situation, and they first arose in the malpractice context, the necessity for that rule, because you couldn't possibly expect people to know about an injury that hadn't yet manifested itself. That concept later became applied to cases of fraud, for example, where you may have an employee who's embezzling money, and it's essentially cooking the books to make it appear as though you're not losing money, but in fact, you as the business owner are losing money because they're stealing it. Most jurisdictions also apply discovery of injury rule to just basic schemes to defraud. There are many circumstances that can give rise to a discovery of injury scenario. For that reason, it's important that you consult with an attorney in your jurisdiction to figure out whether you can benefit from a discovery of injury rule. So accrual relates to when the statute of limitations begins to run, and it's usually postponed until a plaintiff knew or reasonably should have known of its injury. When a plaintiff reasonably should have known of its injury is never a very clear question. A lot of times people will call me and they'll say, I've been experiencing this problem for 10 years, and the defendant has been doing this to me constantly for 10 years. I've been injured for 10 years. I have millions of dollars in damages. I have a great claim. No, you don't. Well, why don't I? Because you've been injured for 10 years and the statute of limitations is only 4. And so you're barred. Oh, no, I'm not barred. These plaintiffs, potential plaintiffs, will always say, I'm not barred because I continue to be injured. The continuing nature of an injury doesn't necessarily restart the statute of limitations. Again, this is a question that varies from state to state and from cause of action to cause of action. But generally speaking, just because you experience more damages doesn't mean that the statute of limitations is restarted. For example, going back to the car crash, say that you sustain property damage and a broken leg immediately at the time of impact. And then 2 weeks later, you also discover that you had a soft tissue injury that you weren't aware of until you got stiff about 2 weeks later. And your doctor says, well, that must have also been caused by the car crash. Does that soft tissue injury, the discovery of that soft tissue injury, then restart the statute of limitations to 2 weeks after the accident? Generally speaking, no, it doesn't. All that soft tissue injury does is it increases your damage claim, but it doesn't restart the statute of limitations. Restarting the statute of limitations would require a new and independent injury. That whiplash or soft tissue injury was caused by the same events that gave rise to your other injuries. It would just increase your damage claim. And so continuing injuries often do not restart the statute of limitations, or cumulative injuries as they're also referred to. You can't assume that just because you continue to experience losses as a result of an event, the statute of limitations doesn't run. The statute of limitations will often run in those situations, and additional damages that you sustain are not going to restart the statute. There are cases where the statute of limitations is restarted. In many jurisdictions, you basically have a new statute of limitations for each installment payment that may be missed. So if you sold a car to someone and you sold it under an installment contract and they were obligated to pay you monthly for a period of 4 years, and they made payments through year 1, but then they quit in year 2 and 3 and 4, and then later in year 6 you then brought suit to recover for the lost payments, you could recover the payments that were owed within 4 years of you bringing the lawsuit, but you couldn't go back to year 1. Anything prior to 4 years would be barred from recovery. Everything within 4 years of filing the lawsuit would still be recoverable. So in many jurisdictions, that's a special rule that applies to installment type contracts, that each missed payment is a new injury that has its own statute of limitations. But again, don't assume that. If you have any concerns, if you have any statute of limitations issues, you need to consult with an attorney to fully understand how the statute of limitations is going to apply to your circumstances. So you've got the statute of limitations period. That's the first issue. You've got accrual. That's the second issue that you got to think about when you're looking at a statute of limitations problem. And then the final issue, the third issue, is tolling. The tolling issue concerns suspending the running of the statute of limitations. The statute of limitations has started to run, but tolling comes in and stops it. Tolling doctrines are all based on equitable considerations, based on ideas of what's fair. Usually it stops the running of the statute of limitations because of a certain disability. And there are several disabilities that will give rise to tolling. One disability that is common and well known is incapacity. So let's say you were in that car crash, and rather than just getting a broken leg, you had a brain injury and you fell into a coma. You would be incapacitated. And although the statute of limitations would begin to run, the claim accrued as soon as the accident occurred. Tolling would step in immediately after the accident and suspend the running of the statute of limitations due to your incapacity. And so the statute of limitations would be tolled for as long as you were incapacitated, or until a conservator is appointed who is given authority to essentially manage the plaintiff's affairs, or at least bring a lawsuit on behalf of the plaintiff to recover the injuries sustained in the hypothetical car crash. Mental incompetence is closely related to incapacitation. Another tolling doctrine is infancy. Prior to the age of 18, you don't have the legal capacity to bring a lawsuit. Your parents can bring a lawsuit, but what if they don't? Most states will toll the statute of limitations on any claim that you may have as a child until you reach majority. Another tolling doctrine is military service. If you're serving abroad, generally speaking, the statute of limitations are tolled for so long as you are serving abroad. There's a doctrine called fraudulent concealment, and essentially that says if the defendant is actively concealing any element of the cause of action from you, the statute of limitations will be tolled. As a plaintiff, you're always required to exercise diligence, even when fraudulent concealment applies. So if you get warning signs, like you notice there's not as much money in your bank accounts as there should be when you look at your books, you better investigate that warning sign. You better find out why there's this discrepancy between your bank records and your internal bookkeeping records. If you don't, you may be found to have lacked diligence, and in that event, the courts will not extend tolling by fraudulent concealment to you. Once you have reason to believe you may have been injured, you really need to research what's going on and figure out whether you've got any legal recourse. Another tolling doctrine which arises in the context of RICO claims quite often is tolling by duress. For example, a defendant says, if you report me to the police or if you sue me over this, I'm going to kill you, I'm going to burn down your house, I'm going to take all of your property. That kind of a threat can result in tolling by duress. There's many other tolling doctrines. Like I said, tolling is based upon equitable concepts, and equity just basically means what's fair. So if you've got any kind of argument that it's not fair for the statute of limitations to run under a given set of circumstances, you can assert a tolling defense to a statute of limitations argument. These are all very complex factual and legal questions that require analysis by a competent legal professional. The sooner you can consult with a lawyer and get their input on these statute of limitations questions, the better off you're going to be. You need to be diligent when you're facing a potential statute of limitations problem. Why do we allow the statute of limitations to exist? Why does that cut off my right to seek legal recourse? There are many reasons why we have statutes of limitations. The most common reason given by legal professionals is that to have an organized society, you need finality. You need to know when a deal is a deal and it's done and nobody can go back and challenge it. You can't just sit back and relax and not worry about it. If you want to seek legal recourse, you have to do it within a particular time period. Otherwise, you're going to lose that right because society demands finality. Because the courts are crowded. Even when you look at lawsuits based on recent activity, courts are overwhelmed. There's more litigation than most court systems can handle. And so if you bring in a claim that's 10 years old or 20 years old, a judge isn't going to feel very sorry for you. I mean, there's lots of people who've been diligent, and a judge is going to look upon their claims more favorably generally than someone who sat around and did not assert their rights in a timely fashion. You can't have claims that are decades old coming into court for the first time and expecting to take up the time and resources of judges and law clerks and court reporters. Statute of limitations are necessary to promote judicial efficiency. So I think the two important takeaways from this discussion are, number one, be diligent. As a plaintiff, you have to be diligent. Don't sit back on your rights and think that, well, the defendant continues to injure me, and so long as I'm injured, the statute of limitations can't run on me. I'll take care of this someday, but not today. Don't think of a situation like that. If you know you're being injured, if you think you're being injured, if you suspect you're being injured, consult a legal professional. And that's the second point. Get legal advice. These are very complicated questions. They're very difficult questions to assess. And they vary from jurisdiction to jurisdiction, from cause of action to cause of action. So And then the facts always matter in a statute of limitations analysis, and you need a competent legal professional to help guide you through all of these issues. And so diligence and counsel, those are the two important takeaways from this lesson. For Law Lessons, I'm Jeff Gorell.